Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the allowability of CSR expenses according to explanation 2 to section 37 subsection 1. As all we know that there was explanation 2 to section 37 subsection 1 which very expressly mentions that if any expense is done according to section 135 of the Companies Act on the corporate social responsibility, that expenditure is not allowable to the company. So the question arises, if a company does not need to incur any expense according to section 135 of the Companies Act on the CSR head, but if the company suo moto incurs some expenses on CSR, whether it will be allowable expense or disallowable expense. This issue has come before the Honorable Gujarat High Court in the case of Adani Power Rajasthan Limited versus Assistant Commissioner of Income Tax. The case has been reported in 461 ITR at page number 210 and the date of the judgment is 19th April 2023. In the present case, the assessee was incurring huge losses and the average loss of the 3 previous preceding years was 187.67 crores rupees. So as per the mandate of section 135 of the Companies Act 2013, the company was not under any obligation to incur any expenditure on the CSR, that is corporate social responsibility. But the company on its suo moto incurred some expenditure and booked it under the head corporate social responsibility into the profit and loss account and claimed it as an expense under section 37 subsection 1. The case of the assessee was selected under scrutiny under section 143 subsection 3 and the learned assessing officer, after making a detailed investigation of the matter, passed the assessment order by allowing the expense on the CSR expenses to the assessee. After that, audit objection came that whatever the CSR expenses have been booked into the profit and loss account, that should not be allowed to the assessee under section 37 subsection 1 explanation 2, and the notice under section 148 was issued to the assessee and assessment was done by disallowing the expenditure. When this matter came before the Gujarat High Court said that first of all, since the case of the assessee has already completed under section 143 subsection 3 and in that assessment the assessing officer has taken the view that the CSR expenses should be allowed to the assessee. So now issuing the notice on the same issue without any tangible material, so in that case it will be a clear-cut case of change of opinion because the learned assessing officer has taken one view and now on the same issue he is not allowed to take the second view. Apart from that, Gujarat High Court said that whatever is disallowed under section 37 subsection 1 explanation 2, that expenditure which has been incurred by the company as a mandate of 135 of the Companies Act as a compulsory corporate social responsibility expense, but if the company is not required to incur that expenditure according to the mandate of section 135 of the Companies Act, but it suo moto incurs some expense and the company thinks that it was necessary for the business purposes and it was helping the company into running of the business. So in that case, it cannot be said that that explanation 2 to section 37 subsection 1 will be triggered and the assessee should be allowed the CSR expenses incurred and claimed as an expenditure under section 37 subsection 1. Friends, this case is a perfect example that in law the situation, the decisions changed just because of the slightest change into the facts of the case So we have to read the bare act of the provisions so that we can know that what is the real intention of the legislature in enacting the law. At the end of this video, once again I am repeating the name of the case. The name of the case is Adani Power Rajasthan Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 461 ITR at page number 210. The matter has been decided by Honorable Gujarat High Court and the date of the judgment is 19th April 2023. Thank you, friends.